Hey guys, in this video, we're going to talk about the latest Supreme Court decision, the one that came out on May 16th, that is really bad for the immigrant community. I'm going to break down for you what happened in the case and what it actually means. Thank you so much for watching this video. I'm LaToya McBean Pompey, an immigration lawyer in New York, working with clients all over the world on complex family and business immigration matters. Reach out to us at McBeanLaw.com or at 516-866-3900 so that we could take a look at your case and see how we might be able to assist you. Before you go, don't forget to subscribe if you're not already subscribed to McBean Immigration TV, and also hit that notification bell before you go. Let's talk about what happened in this case. This was a devastating blow, I would say. This is the Patel case. Mr. Patel entered the country illegally in the 1990s, and then he filed for adjustment of status in 2007. And you might be saying, well, how is it possible that he applied for adjustment of status in 2007 if he entered the country illegally? Well, there's a small amnesty, so to speak, that's in our system, on our books, that says that if an individual had filed an approvable I-130 family petition or an I-140 or labor certification application on or before April 30th, 2001, he or she may apply for adjustment of status. And that's exactly what Mr. Patel did, and he added his wife to the process. The process to adjust your status and get your green card here in the United States, it's a discretionary process. The government, although it has its rules, and you need to meet all of these criteria, but then the other thing that you need to remember is that it's discretionary. They have the decision whether or not to give it to you based on a number of factors. In Mr. Patel's case, what happened to him, unfortunately, is that while his adjustment of status application was pending, he applied for a driver's license in Georgia. On that application, he claimed that he mistakenly checked the box to indicate that he's a U.S. citizen. When the government was working on his adjustment of status application, they discovered this and they denied him because he falsely claimed to be a U.S. citizen. Falsely claiming to be a U.S. citizen is one of the unpardonable sins with immigration. It's very, very difficult to overcome. In fact, there is no waiver that one can apply for to ask for forgiveness for this. And particularly there is a waiver, but the act of falsely claiming to be a U.S. citizen must have occurred before a certain date in 1997. That's the cutoff date. And in Mr. Patel's case, he checked that he is a U.S. citizen in that box in 2007, I believe. Okay, so no waiver is available to him. Fast forward several years later, the government placed him in removal proceedings. And the reason why they placed him in removal proceedings is because he was an alien present here in the United States without papers. That was literally the charge. In court, he again sought adjustment of status through the judge, and the judge, unfortunately, the judge made the decision that, he doesn't have any credibility with the court, and he lost credibility with the court because of primarily two reasons. The first is that he testified in court that when he filled out his application for the driver's license, he also indicated his A number on the application. Therefore, it was clear that he was a non-citizen, and he never intended to check that box that said U.S. citizen. It was purely a mistake. That's it, mistake. And that was his testimony in court. However, the actual application for the driver's license didn't include his A number. So the judge had a problem with that. The judge also had a problem with the fact that he had an asylum application that he had filed previously, whereby he misrepresented how he came into the United States, his entry. So the judge didn't believe that he didn't have the intent to say that he's a U.S. citizen on his application. He just lost credibility due to the other misrepresentations that are on his record. Now, there were factual errors actually that the judge made. Okay. The judge made some errors as well. And that was part of the argument that Mr. Patel had as he moved his case all the way up to the Supreme Court, that this judge made some mistakes here in looking at the facts of my case. And therefore, I need a higher court to review the decision and possibly overturn it. Well, he then appealed his case to the 11th Circuit Court of Appeals, and they determined that they don't have the jurisdiction to look at this case and review the decision from the immigration court because the law prohibits a federal court from reviewing discretionary decision. And adjustment of status is a discretionary matter. Then he took his case all the way up to the Supreme Court, and the Supreme Court also said the same thing. There is no federal courts do not have the jurisdiction to review these cases that are discretionary. Justice Gorsuch, he is a Republican appointed justice. He disagreed and he wrote an opinion. Today, the court holds that a federal bureaucracy can make an obvious factual error, one that will result in an individual's removal from this country, and nothing can be done about it. No court may even hear the decision. It's a bold claim promising dire consequences for countless lawful immigrants. He also says, sometimes a bureaucratic mistake can have life-changing consequences. Our case is such a case. An immigrant to this country applied for legal residency. The government rejected his application. Allegedly, the government did so based on a glaring factual error. In circumstances like that, our law has long permitted individuals to petition a court to consider the decision or the question and correct any mistake. I agree with him, guys. This decision is pretty harsh. Even the government was arguing that they think that this change in the law is necessary, that federal courts need to have this ability to review factual errors that are made, particularly in these administrative proceedings, these removal proceedings, because an entire life and family potentially is impacted by the decision. And so in Mr. Patel's case now, he and his wife are facing removal from the country as a result of this Supreme Court decision. As you heard the facts of this case, I want you to think about yourself, right? From the standpoint of applications that you're filling out, that you're filing, particularly for a driver's license or something like that. And be very careful as you do stuff like that, because it can come back through the immigration process and harm you if there is even a mistake, sadly, as laid out in this Supreme Court decision. I hope you found this helpful. Be sure to share it with others. Comment below. Let me know what your thoughts are about this decision. And guys, I will see you in the next one. Bye-bye.